Hello everyone, welcome back to the Legal Hour. I'm Michael Galyen with Bailey Galyen Attorneys, and today I'm joined by my colleague, Kern Lewis. Kern, how you doing?
Good.
Good. Well, today we have some interesting topics that I'd like to talk about. But first, I'll give you an opportunity to introduce yourself, tell the people what you do for a living.
I'm a trial attorney at Bailey Galyen, and I'm the director of the catastrophic injury section.
So let's dig into that a little bit. What is meant by catastrophic injury?
So a catastrophic injury is one that is more significant than what you might see in a typical car wreck of a hurt back or things like that. Catastrophic injury refers to one that is life-altering, majorly impacts one of the activities of daily living. So for example, you're either maybe a quadriplegic or a paraplegic, or you've got a brain injury where you're not going to be able to continue working. You're going to be significantly impaired and require medical treatment for a long period of time into the future.
Got it. And so you mentioned before catastrophic injury, trial attorney, and I think that those two things go a bit hand in hand. When we're dealing with things such as catastrophic injuries, most of those involve, for the most part, heavy forms of litigation and up into including trial sometimes.
Yes. Of course, most cases settle.
Right.
I hear numbers 80-90% of cases settle, but they still go through that litigation process before they settle. And a lot of times the reason they settle is because the sides are prepared for trial. They know trial is inevitable if they don't resolve the case. And so then they can make a judgment as to, is it in our best interest to settle? So you have to work the case up as if you're going to trial, and then it might settle shortly before the trial.
Right. And in my experience, it seems as though the benefit in working up a case as though it's going to trial through discovery, depositions, written discovery, expert depositions, all those sorts of things, is that the parties kind of know what the trial is going to look like, right?
You ought to be prepared to the point that there are not many surprises that are possible, because you know what the witnesses are going to say, you've taken their deposition, you've done all the detective work, and so you know how all the pieces are going to fit together. You may view those differently from the other side,
sure,
but you know what the evidence is going to be that's going to come in.
I've heard a lot of lawyers talk about that in the past the practice wasn't really quite this way, so discovery intensive, that trial was a bit like the Wild West and like some of the shows and movies you may watch where a surprise witness comes in and throws a wrench in the whole thing, but that's not really the way things happen these days, is it?
No, so I started practicing in 1986, and that sounds like a long time ago. And I got in on just the tail end of that, the way things were done, where cases, you would literally get the file 3 or 4 days before the trial and say, here, go try this.
Mm-hmm.
And you would meet the witnesses at the courthouse for the very first time. And so it was very possible that a huge surprise would happen. Also, the people didn't spend the money on discovery like they do now, where they had deposed every witness. So you didn't have the confidence that you have now as to what they were going to testify to.
Right.
So it was very possible there could be big surprises.
Well, and you mentioned, the expense of discovery. When we talk about discovery, the written discovery process is not all that expense heavy, but when we're talking about depositions and experts, you have court reporters and you have videographers, and I mean it's tens of thousands of dollars easily on every single case, right?
Yeah, absolutely. When you think a defense lawyer, and I'm not a defense lawyer, although I started out as a defense lawyer, they bill by the hour.
Mm-hmm.
And let's say the average defense lawyer bills the insurance company, who is usually their client. They
Right.
may say they represent this company or that person, but they're really being paid by an insurance company. Let's say their average hourly rate is $200, $250 an hour. So you go do a deposition that takes 6-7 hours, or it's a full day. And then they probably spent the day before that preparing. So you've got 20 hours at $250 an hour just for one deposition. And if you've got a case with 15 or 20 witnesses in it, those numbers add up.
Yeah, absolutely. I mean, and I guess that's why we see these days a lot of insurance companies maybe wanting to settle cases before heavy litigation is necessary, because some of them understand the expense associated when dealing with an attorney such as yourself that's going to go and take all the depositions and do the discovery necessary to prepare a case for trial. They realize, one, well, if we go to trial, we may get shellacked, but two, we're going to spend a whole lot of money just preparing this case for trial, because Kern's going to actually do the work, and our attorneys are going to have to be there to defend it.
It's possible. I find that to be heavily influenced on the seriousness of the case. So if it's a $50,000 car wreck case, the insurance company can figure out very quickly the cost of defending this is going to be greater than the cost of just resolving it now. But in a case like the ones I work on, where the damages can be $3 or $4 or $5 million,
right,
they're going to invest some money on the front end to see if they can try to lower that money, the total responsibility, because it's a good business decision for them.
Sure.
So you have to get to a point where they recognize what's inevitable. That train coming down the track isn't getting smaller, it's just getting bigger. Then they'll make the business decision to try to resolve the case.
Right. And, as clients that may go through this, or individuals that may go through a life-altering incident, it's easy to take it personal because, this is their life. But both in your experience as a defense attorney, as you started out, and all of your time as a plaintiff's attorney, I mean, to these insurance companies, it's just another number on a ledger or an algorithm in a computer, right? I mean, there's nothing personal to them about it.
Well, the adjuster who's handling the case has to report to a supervisor adjuster, and that supervisor adjuster reports to a claims committee, and the claims committee reports to someone else. And so it's very easy for the human element of the case to get lost in all those levels of bureaucracy. And the adjuster knows that he's going to be graded not on whether or not he does the right thing or the fair or the just thing. He's going to be graded on how much he resolves the case for. And if he or she is able to get a discount, that's a feather in their cap. So they're going to work to try to negotiate the number down. Just as a matter of self-preservation, it's good for their career that they don't pay too quickly. I had one adjuster tell me that they cannot, at their company, they can't settle a case until they can document the file that they've made 10 different offers of settlement that were rejected before they get to the final number. In other words, if it's a $100,000 case, they first have to offer $5,000, then $10,000, then $50,000, then $62,000. They have to go through all of these levels of trying to lower it before they can ever pay the $100,000.
Right, and that's, I mean, not just one insurance company, but you see this all the time from different adjusters, that they're never coming with their top offer first.
Oh no.
Yeah. Well, let me switch gears a little bit to the types of cases that you handle. You mentioned they, for the most part, all involve catastrophic injuries, but what type of scenarios are we talking about?
I have, so I've been doing this almost 40 years. In the 38 plus years I've been doing it, I've handled cases, medical malpractice. I've got a medical malpractice case right now where a person died on the operating table because a physician cut an artery that they weren't supposed to cut. I've had 18-wheeler accidents. I've had oil field injuries, toxic gas exposures. There's a really wide range of events. Equipment malfunctions, products liability cases. So there's Dram shop cases. There's a wide range of things.
You mentioned Dram shop, and for our viewers out there or listeners that don't know what that means, could you give a quick 30,000 foot view, and then maybe we can dive a little bit into that, because I think that's an interesting area that most people don't necessarily understand.
Sure. So in old England and Scotland, when they sold alcohol, it was sold in a measurement called a dram. So
Okay.
they sold whiskey by the dram. And as a result of that, over time, legal actions that are based upon a bar or a restaurant or another provider of alcohol serving too much to someone who's intoxicated, and then that intoxicated person goes out and causes harm to someone else, those became called dram shop actions based upon that measure of selling whiskey at a dram. Those are relatively new in Texas, in that they came out in the 1980s. That prior to 1987, you couldn't even sue someone for providing too much alcohol to someone, getting them intoxicated, and then them going out and causing damage. But in 1987, there was a case called El Chico versus Poole, where the Supreme Court changed the prior law that basically said, look, if you get drunk and hurt someone, it's your own fault. They changed and said, wait, there was someone who provided you that alcohol. And the question is whether they were negligent in providing you the alcohol, meaning, for example, if you're at a restaurant and you're drunk and you're slurring your speech and you're stumbling, and they know you're going to drive yourself home because you're not with anybody, or maybe the bartender has asked you, how did you get here? Oh, I want my car keys or whatever, give them. Then it's negligent for that establishment to continue giving you alcohol and get you drunker and let you get out on the road. So the Supreme Court in 1987 said they have a responsibility to the public. Right when that opinion came out, within days of that opinion coming out, the legislature enacted a new law that is in the Alcoholic Beverage Code that says a provider of alcohol can be held responsible if they served someone who was obviously intoxicated at the time they were served.
Okay.
And that's a key point. We can talk about that in depth, because that's where the fight usually is, on whether or not they were obviously intoxicated.
So, to back up a little bit, the idea is whether it's a bar, a restaurant, some other establishment that has the ability, or in this case a license, to sell beer, wine, liquor, they can, if they overserve somebody who's obviously intoxicated, be held responsible for the damage that intoxicated individual goes and causes. Let's say on their drive home, they crash into somebody. What exactly needs to be proven that the bar did wrong?
Well, the key element is whether or not they served someone that was obviously intoxicated. So it's not that they served a bunch of alcohol to someone.
Right.
You have to prove they served it to them when they knew they were intoxicated.
Right. So this isn't necessarily because I can understand this myself, and I'm sure a lot of people will have the same reaction of, well, people should, they're grown-ups, they should make their own decisions, and if they're going to decide to drink a lot, why is that the bar's responsibility? But you make an interesting point that the establishment has to know that they're obviously intoxicated when they're serving them. I think at that point you're kind of saying, look, this person is intoxicated, they no longer have the mental ability to make those smart decisions for themselves. We as a society have said, look, we'll give you the ability, you the bar, you the restaurant, to sell alcohol, but you have to make the right decisions in doing so. And if you determine that this person's obviously intoxicated, stop serving them alcohol.
Right.
Is that a fair description?
Yes. The bar makes money, I say bar or restaurant,
Sure.
makes money from serving alcohol. So there's a benefit to them of being able to sell alcohol. But with every benefit comes a responsibility. And so they have a responsibility not to just be completely selfish and say, well, we don't care if he kills 20 people on the way home. We ran up a big bar tab and got rich off of that. we all live in this world together. There's a responsibility to each other. The individual who's drinking, of course, they've made bad decisions. But there's a point at which they become intoxicated that we recognize their judgment is impaired.
Right.
They obviously aren't going to make good decisions from that point on. And for you to contribute to that by just giving them more and more alcohol, when you know they're going to have to leave there and get home some way, then you're participating in that problem.
Right.
And therefore you have to take responsibility for it.
I think that's a great way to describe it. But the legislature also, when they came out with these laws, included, I think it's called a safe harbor provision. What exactly were they trying to accomplish with this?
Well, they were trying to encourage bars and restaurants that serve alcohol to learn how to be more responsible in doing that to prevent the problem before it begins.
Sure.
So they created an incentive for the restaurants and the bars that if you will have all of your servers trained through a course that is offered by the Texas Alcoholic Beverage Commission or approved by the TABC, that if you will have them go through this course, that they've received the training on how to recognize people who are intoxicated, how to cut them off and stop serving them to prevent the problem from beginning. If you will go through all the training, we're going to give you a special defense. If you get sued for this and you prove that all your people had gone through the training, you get an additional defense that other people don't have. And that's called the safe harbor provision. You can still get around the safe harbor provision if, for example, some ways that I've had cases in the past where we got around the safe harbor provision. The law requires that everyone be trained. So if you've got 10 servers and one of them is not trained, you don't qualify for the safe harbor provision. And this training is also good for a limited period of time. You have to redo it ever so often. And if someone's training, they had it in the past, has lapsed because it's been 3 years since they had it, and you as the owner don't make them renew their training, you don't qualify for the safe harbor provision.
Okay.
So I recently had a case where you had a big restaurant bar facility, and they had one person who worked that night. So what I do is I go to the list of everyone who was working the night that the incident happened, and I check every one of them's certification, and I had one person who was not certified. Safe harbor provision didn't apply.
Interesting. And that's exactly how the legislature determined that these bars and restaurants will get the defense if they follow those rules. So when they don't, no extra defense.
That's right. That's the hurdle they have to meet to get this defense. And the legislature decided the encouraging of getting them to all get the training was worth it. They wanted to incentivize that with this defense, but they set a standard. It has to be everyone.
So an interesting point that we've kind of discussed a little bit with these types of cases is the obvious intoxication, right? The bars or the server or the bartender, or it could be a grocery store attendant, whatever the facility is that's serving this obviously intoxicated individual, they have to be obviously intoxicated, right? Like we're saying, but what exactly does that mean?
Well, and that's subject to debate, and so when these cases come up, that's where the discovery is focused for most of the time, is what are the signs that it was obvious they were intoxicated. So, for example, you might have security video from the facility in which you can see the person is stumbling and staggering and falling down, and then they're continuing to serve them. That's the gold standard if you have that. Or maybe you find out the identity of other people who were at the bar that night who said, oh yeah, that person was, singing out loud and being boisterous, and they were obviously drunk, and they continued to serve them. That's key testimony. Or you may get the person who was with the drunk or the intoxicated person One of their friends says, "Oh yeah, he was hammered," and then you can also prove it a little bit by circumstantial evidence, to an extent, circumstantial evidence. So if you can get their bar tab and show they had 10 drinks, in a 2-hour period, that's some evidence that they were intoxicated, but you have to corroborate that with some other evidence that they exhibited signs that would have made it obvious to the server, if they were paying attention, that they were intoxicated. And I can go into some of those if you want.
Yeah, no, I mean, this is interesting to me, so to continue, please.
So if you've got, let's say the person is drinking and then they leave the restaurant, and 3 to 5 minutes later down the road they get involved in an accident, and at the scene of the accident, witnesses or the police officer or the ambulance personnel who responds says, that guy was wasted, we could smell it, we could see it, he was slurring his words, he couldn't stand up straight, whatever. Then you've got a very short period of time that has elapsed since he left the bar, we'll just say bar or restaurant. You've got a very short period of time in which he was obviously intoxicated, so you can infer that didn't start in those 3 to 5 minutes after he left. It had to have existed while he was still there. Right. And so then you go back and you look at the tab and say, well, was he still getting drinks served to him around that time? Or had he been at the bar for 4 hours and all of his drinks were 3 hours earlier? Then the bar's going to say, well, yeah, he might be intoxicated now, but he wasn't when we served him.
Right, so I guess that brings up an interesting point, because you say, leaves the bar 3 to 5 minutes later is in the incident or accident. What happens in a scenario where there's maybe an hour, 2-hour gap of unaccounted for time after they leave this restaurant or bar?
That creates problems that requires a lot more detective work to try to figure out the facts. So there was a new case from the Texas Supreme Court that came out just in April of 2025, so just a few months ago. And that was the problem in that case. The person had left the restaurant at approximately 11 p.m., gone to a friend's house, and then done some other things, and then they weren't into an accident that the police officers responded to until 3 a.m. So 4 hours elapsed. And so it became a big dispute of, well, yeah, at 4 a.m., they're intoxicated because of their blood alcohol level showed they were intoxicated. But even the police officer at the scene said he didn't look intoxicated. There was nothing about, he wasn't slurring his speech, his eyes weren't fixed and glassy, he didn't have a strong odor of alcohol, all the normal things that they rely on. So then you had, wait a second, how can you say he was obviously intoxicated at the restaurant 4 hours earlier,
right,
when here a trained police officer couldn't even tell he was intoxicated until they made him take a breath test? And in that case, the Supreme Court said that's the circumstantial evidence is essentially no evidence that he was obviously intoxicated to the personnel working at the restaurant.
Well, and then to a certain extent, you run into the issue of, because as the plaintiffs, it's our burden to prove our case, right? The defense doesn't have any burden, and they can kind of just kick up the dirt and throw mud and see what sticks, and that's how oftentimes they're successful. So in that example, the defense attorney could say, well, look, he was at a friend's house, he did this, he did that. How do we know he wasn't drinking that whole time?
Exactly.
And so even if the police officer did say, he did look intoxicated to me, what would stop them from saying, well, yeah, but there was this 4-hour gap, He probably, if he didn't continue to drink, he maybe would have sobered up, but the fact that he still was so intoxicated at the scene means he must have drinking in between that time.
Well, and then you get into the scientific evidence, and in these cases, we hire toxicologists,
right,
who are experts, usually with a PhD in toxicology, and there's a lot of science, excuse me, there's a lot of science and scientific studies and articles that have been written about intoxication and how they can track a person's blood alcohol level, and they can do these calculations, mathematical calculations based on the person's height and weight, body fat, all these kinds of factors they can put into this equation, and they can come back and say, okay, 1.5 hours earlier, his blood alcohol level must have been this. And 3 hours earlier, his blood, and then based upon that blood alcohol level, there are a bunch of studies that say a person would have exhibited these signs or symptoms. They would have been slurring their speech. They would have been slow executive function, like in carrying on a conversation. They would have been slow to respond. They would have had a fixed glaze, like if you've ever seen a drunk person, sometimes they'll be like staring at your chest while they're talking at you just because they're focused. They've got a slow gaze. So again, that's a lot of circumstantial evidence you can try to put together. The defense lawyer, the defense lawyer's favorite word is always speculation.
Right.
Oh, you're speculating. You're speculating that this happened, and you're speculating that that happened, and so it's not reliable. But then again, their whole case is also based on speculation that your person might have done this, and the person might have had alcohol from a different source. Well, they're speculating. So you have to try to get past all that down to what do we know and what's the most reasonable thing to occur. In the recent case from the Supreme Court, for example, even though the person was not in an accident until 3 a.m., the person testified, I didn't have alcohol from any other source. I left the restaurant, and that was it. I went to my girlfriend's house, and then I didn't drink anything there. And the girlfriend also testified, no, we didn't have anything to drink after he left the restaurant. So it wasn't just speculation. There was evidence that established where they had the alcohol.
Right, and in that case, the jury, they're not supposed to speculate if that's all the evidence that they have in front of them, being the testimony of the drunk driver and the girlfriend that there was no alcohol consumption after the restaurant or bar, then that's what they should rely on in making their determination.
Right.
How about the drinking before? We mentioned after, but do you see sometimes in a lot of these cases that maybe the bar or restaurant that is being alleged to have served somebody who was obviously intoxicated, this person may have drinking somewhere else before and then showed up to that bar?
And I've had 2 cases in the past 2 or 3 years, both of which involved people who either drank at home or drank at one bar, and then they went to another bar, and sometimes even a third bar, because they're bar hopping.
Right.
That's what's the thing. Or sometimes, frankly, these are just people who have an alcohol problem and they're indulging in that. I had a recent case where a guy went to 3 different bars before the accident, and the question became, because we had in the lawsuit we had all 3 bars, how much did he drink at which bar, and trying to figure that out can become a mess. And each bar then tries to point at the other bar saying, well, they're the ones who got him intoxicated, or he wasn't intoxicated when he came to us, but he would have been intoxicated before he went to the next bar, therefore it's all their fault. And there's a lot of detective work that is involved in these cases of trying to piece together, where they drank and how much they drank at each spot, and creating a timeline. And that kind of creates another issue that comes up in a lot of these cases. You've got a person who causes an accident on their way home from the bar, so they're charged with drunk driving.
Right.
And they're going through the criminal system at the same time of waiting on their charges to be resolved. And while that criminal proceeding is going on, they're not going to provide you any testimony or evidence about what they were doing that night. If you try to ask them, even if you include them in the lawsuit, and you try to ask them, so where did you drink that night? They're going to take the Fifth Amendment.
Right.
Because that testimony could then be used by the district attorney in their criminal case to say, aha, you've admitted you had 5 drinks at this restaurant and then 3 drinks at that one. So they're going to take the Fifth Amendment. And there's nothing you can do about that other than wait it out and hope that their criminal case gets resolved before the deadline runs on your civil case that you need that testimony, so that you can then say, wait, You've already finished your criminal case. You don't have a Fifth Amendment anymore. So now you need to tell us, where did you drink? How much did you drink? Who were you with? And you can get that information. And so it becomes a race against the clock.
Right, and a lot of the counties, the bigger ones, the more busy ones, the district attorneys can't, in a lot of cases, resolve the criminal action before our deadlines in the civil action. So, in those, I mean, what types of detective work have you done in the past? And if you have any examples, I'd be interested to hear.
Well, in one recent one I had, we were lucky that the person about a month before the statute of limitations ran. So statute of limitations is the deadline in which to bring a lawsuit,
Right.
a civil lawsuit. And in Texas, for most things that I'm involved in, it's generally a 2-year statute of limitations. So let's say if they drank on December 1st, or the incident happened on December 1st of 2020, you have to file your lawsuit by December 1st of 2022.
Right.
And you don't want to wait till the last day. You really want to be filing it 6 or 8 months prior to that. But that's your absolute deadline. So if you don't know where that person drank, because they were drunk, they had an accident, they got arrested, but they've never told anyone where they were served the alcohol, you're getting very nervous as it gets close to the 2-year anniversary date, because you don't know who to sue.
Mm-hmm.
So I've been lucky in that one of them, about a month prior to the statute running, he finally cut a deal with the prosecutor where he said, okay, I'll tell you everywhere I went. We contributed to that deal by telling the prosecutor, look, I know you want to go and have a conviction and all that kind of stuff. The family, if we're doing what's best for the family of the person who was injured, you need to cut a deal with that person before the statute runs so that we can get that information. And the prosecutor then made a plea bargain offer to the defendant, the drunk driver, saying, look, we'll do this sentence, we'll offer these terms that are a little more favorable than I might offer, but a condition of that is you need to cooperate. You need to show your remorse for the harm you've caused by cooperating in the civil case. And so then the person did that and said, okay, here's where I was and here's how many drinks I had.
Yeah, and in that case, I mean, sure, the prosecutor may be cutting them a deal, but ultimately that's the best case for this family.
That's justice, you
Right.
know, and the prosecutor is acting in the best interest of everybody involved. Maybe the person gets a little less prison time, but it's able to help the other people down the road and help the victims. And isn't that the true goal of the justice system?
Right, because when we're talking about catastrophic injuries or death, but especially catastrophic injuries, you know, that money that the family may be able to recover ultimately from the establishments that were negligent is going to make their lives so much easier, whether it be paying for in-home nursing care or the right medical equipment so that they can get in and out of the shower or in and out of bed. I mean, that sort of stuff makes such a big difference for these families' lives.
Absolutely. In the case I'm thinking of, the person who was injured by the intoxicated driver was actually in a nursing home in a semi-vegetative state requiring 24-hour care. Mm-hmm. And the money that we were able to recover in that lawsuit went into a special needs trust for the benefit of this person. So even though they're in a nursing home, they were able to get a little better bed, a little more comfortable this. They were able to get some therapies that maybe their insurance wouldn't cover. And so it does make a dramatic difference in their life, even though it doesn't put them back to where they were before by any stretch of the imagination.
Sure.
And that's good for the family to know that they're better taken care of.
Well, you mentioned that example, and I know to a certain extent, even though these are, you know, lawsuits that you filed and some of this stuff is public information, there are certain things that you can't necessarily talk about. But what are some of the others that you've seen recently?
Other dram shop cases?
Yeah,
or-
yeah.
So I had another one with some people that went to they had gone several different, they drank at home, and then they had gone to one bar, then they went to another bar. And one of the person who was ultimately injured was underage. So shouldn't have been drinking at all.
Right.
And then that person was a passenger in the car as they left the bar, and they hit a telephone pole. That person was horribly injured, became paraplegic, meaning she was a quadriplegic, meaning she had no feeling below about her shoulders. So she couldn't move her arms, she couldn't move her legs, she was in a wheelchair, she was on a respirator. And we resolved her case, and then she died shortly after. So, I mean, the tragedy just continued. But she lived for over 2 years in that condition before she passed away.
It's terrible.
It's horrible.
You'd mentioned that she was underage. Does that make a difference for the purposes of the dram law?
Absolutely. It makes the provision of alcohol, a lot of these things about obvious intoxication don't apply when they're underage. When they're underage, you're not supposed to be serving them at all.
Sure.
So that in terms of what you have to prove, it greatly simplifies the case. Now, of course, the establishment is still going to say, well, we didn't serve her, we served her friend, and then her friend shared the drinks. And the response to that is, when you've gone to the table and there's 2 or 3 people sitting there, you need to be monitoring how many drinks you're serving to that table, because then you know it's being shared. So you still have some responsibility, and you need to be watching to see if they're sharing it with people who are underage.
Right, maybe check all their IDs, or
Absolutely.
It's a red flag if a table of 4, one person for some reason has ordered 12 drinks.
Yes.
You'd mentioned a little bit about what ultimately, you can recover for these families, but if you could go into a bit of detail, what sorts of damages are these injured individuals requesting when we have these types of lawsuits?
Well, for the cases I handle where the injuries are catastrophic, meaning they're continuing, the first thing is medical.
Right.
You've got medical that they've had in the past. They may have had multiple surgeries already. They may require nursing care at home. They may require all kinds of physical therapy, stuff like that. So you've got that in the past, and then you've got it in the future. So in the case where you've got the young underage person who was a quadriplegic, you are looking at a potential lifetime of care.
Right.
And if they're 20 years old, you could be talking 40, 50 years of medical care into the future. So you've got to look at past and future medical care. Then you've got lost wages. Someone who's catastrophically injured is not going to be able to work. And so you've got to calculate not only what kind of lost income they've had in the past, but what their income in the future would have been. And I know a lot of people get very upset when you talk about big damages, and they think it's like a lottery, that people are winning the lottery. Oh, they're going to get $5 million. Well, the other way to look at that is, let's say that's $3 million of that $5 million is future wages. It was a 20-year-old person, so for the next 45 years, until they would have been 65, you've been able to calculate what they would have made as an income that they're now not going to make. Well, if they're disabled, that means they're probably receiving some kind of government benefits.
Yep.
And they become dependent on possibly welfare or other programs and stuff. When you recover that money for them, that lessens their dependence on all those programs. So it's really a benefit to the taxpayers that the person the restaurant, the bar that's responsible for this situation is the one now having to pay for it, rather than the taxpayers being required to foot the bill for taking care of this person through Medicare or Medicaid, through welfare type benefits, Social Security, disability. So we're actually doing a service to the public of reducing that responsibility for those monies in the future and putting them on who's really responsible for the event.
Yeah, absolutely. I think that's a fantastic point. I mean, why not punish the wrongdoer? Why would you push that responsibility back on society of the taxpayer through all these government programs that ultimately, if this person is unable to recover the funds from the negligent party, that they're going to have to rely on?
It's like the old saying, if you break it, you buy it.
Yeah.
You know, or if you broke it, you're responsible for fixing it.
Yeah, and ultimately either, resolution comes in the form of a settlement, they agree to pay a certain amount, or two, a jury determines, they were responsible and here's how much they need to pay, and that's obviously based off the evidence that's presented at trial. But in terms of settlements, I think you'd mentioned that for these sorts of cases and examples that we're talking about, you can't really talk numbers, can you?
No, almost every large settlement that I've had in my career has had a confidentiality clause as part of the settlement. Of course, the bar or the restaurant or whoever's having to pay the money, or their insurance company. Right. Most bars and restaurants carry alcohol liability insurance, so they've purchased insurance to cover that, so they're not being put out of business by these verdicts. They've already factored that into their business model. But they will want a confidentiality clause because they don't want anyone going out and saying, look, XYZ restaurant just paid $2 million because of this. They want to keep it quiet because that's bad for their business. Mm-hmm. And while normally there's a part of me that would say, hey, part of responsibility is the public needs to know who the bad actors are out there. My ultimate responsibility is to my client. And it's not in my client's best interest for them to not be able to get the settlement because the restaurant or the bar wants to keep it quiet. If I'm insisting, no, the public needs to know, and the bar saying, well, we're not going to pay if you're going to do that, well, that's not good for my client.
Right.
And the other issue is, it's not good for my client for the whole world to know they just got access to a large sum of money, because people will come out of the woodwork wanting to be their best friend or wanting to borrow money, or potentially, setting them up to be a target for some kind of scam or something else. So it's better for my clients that the whole world not know their personal business. So that's why I'm amenable to those kinds of agreements that have a confidentiality clause, and most cases do.
Yeah, that makes sense. Well, we've talked a lot about cases you handle, a lot about the Dram Shop cases specifically, but before I let you go for today, is there anything else that you think we've missed as it relates to these sorts of cases or the types of cases that you're handling these days?
Can't think of anything.
Okay. Well, everyone, this has been another Legal Hour podcast at the Legal Cafe in downtown Fort Worth at the Bailey Galyen office. We've been speaking with Kern Lewis of Bailey Galyen, Director of Catastrophic Injury Department. Kern, thank you so much.
Thank you.